Hello, hello, all those beautiful faces. Welcome to Teaching Liberty live on this Saturday night, July 15th. And my name is Stephanie Edmonds, and tonight we are going to be discussing a Supreme Court decision, Groff v. DeJoy. There are, of course, many headlines and news stories we could cover, but I think that this one is important. I haven't seen as many headlines on it, of course, as the affirmative action case, which we did go through, a week and a half or 2 weeks ago now. And I think that a lot of these news stories that come up day to day, we watch here, we go there, trying to follow the headlines, and we're actually missing some of these bigger, more consequential happenings that actually frame these day-to-day news stories. And we seem not to be able to understand what's going on because we're missing things like Groff v. DeJoy. So we're going to go through the decision. We're going to read the ruling, and it's actually a 9-0 decision. It's about religious exemptions, and it's very consequential for many of the things that have gone on the past few years with the mandates, both for masks and for vaccines. Interestingly, this case has nothing to do with the pandemic. It actually was filed in court pre-pandemic, and the events were, I believe, in 2017 and 2018. It has to do with a postal worker who wanted Sundays off to observe his religious practices, and he was having trouble getting that day off. So we're going to go through all the details, but before we do that, I have to ask you to go ahead, hit that like button. If you're new here, welcome. Hit that subscribe button so you can get notified when I drop these videos, because like I said, there's lots of new people who cover the news and the daily headlines, but what we try to do here is really bring in that larger context and cover the things that you're not necessarily going to see like popping up on your news feed and catching all the headlines. But these are the stories that matter. So definitely share this link out with your friends. Let them know what we're doing over here at Teaching Liberty. And of course, for more and to support what we do, you can head over to TeachingLiberty.org. I have those links in the description down below, along with my social media. I'd love for you to follow me on Instagram and Twitter. And I think that covers all the things, right? So let's go ahead and get into this case. And actually, I think there is a little bit more context before we get into it, because one of the reasons I wanted to definitely cover this was because on Tuesday, I'll be back in court with New York City teachers. We have our lawsuit sponsored by Children's Health Defense and Teachers for Choice, and we are filing in state court. If you know, I was one of the teachers who was denied religious exemption for the vaccine mandates, and we were fired. So this was back in February 2022. I actually wasn't officially fired until September of 2022. Yeah, of 2022. But we were done in stages. And you can actually see here, this is me. This is from August of 2021. And so again, even though this specific case, Groff v. DeJoy, that we're going to be going through doesn't have to do with vaccine mandates, it has widespread implications that I think are important to consider for cases like mine. Indeed, we know over the past couple of years, religious exemptions have not been easy to get. And we've seen the right to religious exemptions really pushed back against and challenged by employers, by the federal government, by state governments, city governments, really at every level. And in places like Connecticut, New York, I believe California, I'm not sure if there's other states, children have actually lost their right to religious exemption. So this case is slightly different because it has to do with the workplace, but I can definitely see this as a road to restoring some of these rights, whether they be in the workplace or for children in schools. So that's just a little bit of background, and just one more time, we would love your support for our lawsuit on Tuesday. If you are a New York City teacher who has ever filed a religious exemption at any point, whether you ended up resigning or getting fired, if you filed a religious exemption, you need to show up. This is for if you're forced into early retirement, forced to quit. If you filed a religious exemption at some point, we are going to try to be making this a class action lawsuit. Right now, it's DeCappa v. City of New York, and we need to show the judge how many people have been impacted. So it's very important for you to show up. If you're not a New York City teacher and you want to support us, please head over to teachersforchoice.org and you can make a donation to help support our legal battle. And if you're a teacher or a public employee in another state looking for some direction or inspiration, I also recommend checking out what's going on over at teachersforchoice.org and reaching out to Michael Caine even. He's the person who started Teachers for Choice, and I believe that he'll be able to provide you with some direction, and you can see the legal arguments that we're making. So let's go ahead and get into this specific case, Groff v. DeJoy. So if you go over to the SCOTUS blog, this is independent news and analysis on the Supreme Court. It's really nice because they bring up all the very key information here, and they have some articles that you can read with analysis, and then here they'll show you all the different dates of the different actions taken. So it was initially filed in the Supreme Court just under a year ago. But of course, to get to the Supreme Court, that means it's been in the lower courts for some time. So this, like I said, this case dates back before the pandemic, has nothing to do with the pandemic. We're going to get to the details in a second. I just think it's important to understand where you can get this information and how you can get straight to the source and not, be influenced by these headlines or by this analysis that has an agenda. So here's the actual Supreme Court decision. It's only 29 pages, which might seem like a lot, 29, but in comparison to the affirmative action decision that we were reading, which I can't remember if it was over almost 200 or if it was over 200, but it was substantially longer. And so we should definitely be able to get through this decision in the next hour and talk about it a little bit. Again, break down some of what the actual, what they're actually saying in here, trying to make sure that we understand it, put it into our own words, and then think about, well, how might this apply or impact other situations or things that are going on in the world? So Groff v. DeJoy, Postmaster General. So this, again, this has to do with a United States postal worker. And the petitioner, Gerald Groff, is an evangelical Christian who believes for religious reasons that Sunday should be devoted to worship and rest. In 2012, Groff took a mail delivery job with the United States Postal Service. Groff's position generally did not involve Sunday work, but that changed after USPS agreed to begin facilitating Sunday deliveries for Amazon. To avoid the requirement to work for Sundays on a rotating basis, Groff transferred to a rural USPS station that did not make Sunday deliveries. After Amazon deliveries began at that station as well, Groff remained unwilling to work Sundays, and USPS redistributed Groff's Sunday deliveries to other USPS staff. Groff received progressive discipline for failing to work on Sundays, and he eventually resigned. So you can see again, and this dates back to before the pandemic. I believe Amazon came in the picture around 2016 or 2017. And you can see he went through effort to say, okay, you're going to start Sunday service here. I'll go to a different station and I'll transfer out there. And if you read the details of the case, he does try to do shift swapping and all sorts of other things in order to ensure that he can observe his religious practices. Groff sued under Title VII of the Civil Rights Act of 1964, asserting that USPS could have accommodated his Sunday Sabbath practice without undue hardship on the conduct of USPS business. So this is the standard that we have come to know with religious exemptions, that an employer has to accommodate you unless it poses an undue hardship. And this is exactly what this case is going to define and come up with a clearer standard and then send it back down to the lower court. And this, in our case in New York City, for the religious exemptions from the vaccine mandate, this was also what our employer used. They said it poses an undue hardship to accommodate you, therefore we are denying your accommodation. So you can see this is very, very important that employers are not going to be able to just say, well, it causes us a little bit of hardship, so we can't accommodate you. Okay, so the district court granted summary judgment to USPS. The Third Circuit Court affirmed on this court's decision in the Trans World Airlines, Inc. v. Hardison. So again, law, that means that we're going to be referring to other cases, and we're going to learn more about this case and the standard that was set about the undue hardship. So it was construed to mean that requiring an employer to bear more than de minimis cost to provide a religious accommodation is an undue hardship, right? So that's the legal language for what I was just saying. If it costs an employer more than some minimal amount, then they can just deny and say it causes us undue hardship. It's going to cost us a little bit or be too difficult, so we're not even going to try to accommodate you. The Third Circuit found that the de minimis standard met here, concluding that exempting Groff from Sunday work had imposed on his coworkers, disrupted the workplace and workflow, and diminished employee morale. So basically, because his coworkers had to take his shifts, and that didn't really make them happy that they had to make this extra work up, people got angry, and so it wasn't necessarily a financial thing here. It's just more so about other workers not being happy, which is interesting. And what did the court find? The court found that Title VII requires an employer that denies a religious accommodation to show that the burden of granting an accommodation would result in substantial increased cost in relation to the conduct of its particular business. So instead of being just de minimis, a minimal cost or a minimal hardship, it didn't even say cost, it said instead of being a minimal hardship, it has to be a substantial increased cost in relation to the conduct of its particular business. And because it says cost here, I think that this is a very important point, because it doesn't necessarily matter how your coworkers feel, whether it it decreases the morale or makes your coworkers angry. It matters how much it costs the business. That's very important to keep in mind. This case presents the court's first opportunity in nearly 50 years to explain the contours of Hardison. So that case that we referred to earlier, where the de minimis standard came from, that was almost 50 years ago. And this standard has sort of been out there, and in my opinion, it has been watered down. And we saw that happen even more during the pandemic with religious exemptions. And that's why I think the court decided to take up this case now. And I think that it's a very non-political way to do it. Instead of trying to directly touch vaccine mandates, they're doing this sort of just workplace dispute about having your day of worship off. But it has widespread implications for all sorts of religious exemption cases. So Title VII of the Civil Rights Act of 1964 made it unlawful for covered employers to fail or refuse to hire or discharge any individual or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's religion. As originally enacted, Title VII did not spell out what it meant by discrimination because of religion. Subsequent regulations issued by the EEOC, which is the Equal Employment Opportunity Commission, obligated employers to make reasonable accommodations to the religious needs of employees, whenever doing so would not create undue hardship on the conduct of the employer's business. And so if you believe that your employer was discriminating you on the basis of religion, or if you do, you can file a claim with the EEOC, which is a federal agency that will then investigate your claim and decide if you have legal grounds to sue, or they will try to negotiate a resolution between you and your employer. And so over the past 50 years, it's really been the EEOC who has been upholding this standard, the de minimis standard, and determining almost in some ways the case law rather than the courts. So that's almost another discussion on its own, the way that these federal agencies have just expanded their power and taken on, in my opinion, responsibilities that they simply just don't have the power to do. And that's the reason that they've been able to degrade away at so many of our rights, just because these agencies have no oversight, right? They're supposed to be the ones doing oversight, but who's watching them, right? So where are we? All right. In 1970, however, the Sixth Circuit held that Title VII did not require an employer to accede or accommodate a Sabbath religious practice, because to do so would raise grave Establishment Clause questions. And the Establishment Clause is from the First Amendment. We talked about this with another Supreme Court case that we did. The Establishment Clause is saying that the government cannot establish a religion, right? Or a lot of times people think about this as the separation of church and state. And so they were saying that an employer doesn't have to accommodate the Sabbath because that might be construed as them establishing a religion. So I don't agree with that interpretation, but that is what the Sixth Court held in this case, Dewey v. Reynolds. This court affirmed Dewey, so the Supreme Court affirmed Dewey by an evenly divided vote. Congress responded by amending Title VII in 1972 to track the EEOC's regulatory language and to clarify that employers must reasonably accommodate an employee's or prospective employee's religious observance or practice unless the employer is unable to do so without undue hardship on the conduct of the employer's business. So you can see here, our lawmakers did not like this decision from the court. They thought that it was overstepping their role as the court, almost legislating from the bench. And so Congress said, that's not right. And we're going to make sure that it's encoded in law that actually an employer does have to reasonably accommodate this observance and practice. And I guess they tried to add in some language to oversee the EEOC. Partisan concerned an employment dispute that arose prior to the 1972 amendments to Title VII. In 1967, Trans World Airlines hired Larry Hardison to work in a department that operated 24 hours per day, 365 days per year, and played an essential role for TWA by providing parts needed to repair and maintain aircraft. Hardison, 432 U.S. at 66. Oh, that's some legal thing. Hardison later underwent a religious conversion and began missing work to observe Sabbath. So at some point after he started working there, he became religious and wanted to have his Sabbath off. Initial conflicts with Hardison's work schedule were resolved, but conflicts resurfaced when he transferred to another position in which he lacked the seniority to avoid working during his Sabbath. Attempts at accommodation failed, and TWA discharged Hardison for insubordination. Hardison sued TWA and his union. The Eighth Circuit sided with Hardison. And so he sued TWA and his union because apparently his union did not stand up for him or was insufficient in their representation of him in this matter. The Eighth Circuit found that reasonable accommodations were available to TWA and rejected the defendant's establishment arguments. Hardison v. Trans World Atlantic, Inc. Okay, so that was the case. This court granted certiorari. TWA's position for certiorari asked this court to decide whether the 1972 amendment of the Title VII violated the Establishment Clause as applied by the Eighth Circuit, particularly insofar as the decision had approved an accommodation that allegedly overrode seniority rights granted by the relevant collective bargaining agreement. At the time, some thought that the court's now abrogated decision in Lemon v. Kurtzman, which adopted a test under which any law whose principal or primary effect was to advance religion was unconstitutional. Posed a serious problem for the 1972 amendment of Title VII. So this case, again, this is how the law works. Sometimes the things that we think it should be looking at aren't necessarily actually what gets taken up by the case. And that really does seem to be what's going on here is, so you have his religious accommodation that he wants, and then you have this whole union that negotiated this seniority thing. So even if TWA did want to accommodate him, it seems because of this seniority scheme where people who have more time on have more say in which days they have on and off, it poses even a difficulty for TWA. And I guess that also is sort of conflicting for his union because his union has to represent all the workers who like this seniority scheme versus this one guy who the seniority scheme doesn't allow to get his day off for his religious observances. But the court is considering whether accommodating his day off would violate the Establishment Clause and mean that the government is trying to get people to be a certain religion. So it's a little bit confusing, but let's see how it plays out. Ultimately, however, constitutional concerns played no on-stage role in the court's decision in Hardison. Instead, the court's opinion stated that the principal issue on which TWA and the union came to this court was whether Title VII require an employer and a union who have agreed on a seniority system to deprive senior employees of their seniority rights in order to accommodate a junior employee's religious practices. Right? So kind of succinctly puts what I was trying to explain there. The court held that Title VII imposed no such requirement. The conclusion the court found was supported by the fact that seniority systems are afforded special treatment under Title VII itself. Applying this interpretation of Title VII and disagreeing with the Eighth Circuit's evaluation of the factual record, the court identified no way in which TWA, without violating seniority rights, could have feasibly accommodated Hardison's request for an exemption from work on this Sabbath. And we're going to see that the decision in this Groff case is going to rework this configuration and not give so much space to the seniority system over religious practices. The parties had not focused on determining when increased costs amount to undue hardship under Title VII separately from the seniority issue, right? So they were really focused on the seniority issue. They didn't define out what does undue hardship mean. They put no financial point on that. Was not at all about the financial aspect of things. It was more about the seniority and other workplace factors. But the court's opinion in Hardison contained its often quoted sentence: to require TWA to bear more than a de minimis cost in order to give Hardison Saturdays off is undue hardship. Although many later courts later viewed this line as the authoritative interpretation of the statutory term undue hardship, the context renders that reading doubtful, right? So even though people have been saying that it's, de minimis is the standard, the case actually didn't have a lot to do with that, and people have just been putting their own meaning into what this sentence means at their convenience. So in responding to Justice Marshall's dissent, the court described the governing standard quite differently, stating 3 times that an accommodation is not required when it entails substantial cost or expenditures. So there was a dissenting opinion on this case that was more focused on these costs and expenditures, but that was not, of course, the deciding opinion. Even though Hardison reference to de minimis was undercut by conflicting language and was fleeting in comparison to its discussion of the principal issue of seniority rights, lower courts have latched on to de minimis as the governing standard. To be sure, many courts have understood that the protection for religious adherence is greater than, more than de minimis might suggest when read in isolation. So basically saying like religious liberties have a very long history, and when we put them in context with this de minimis standard, they've actually been pushed to the side. So it's time for this court to take this up and really define out what this means. But diverse religious groups tell the court that the de minimis standard has been used to deny even minor accommodations, right? And so the Supreme Court really only takes up cases when there are big signals in the lower court that, hey, there's an issue here. I think, again, that's an aspect that a lot of people don't realize about the Supreme Court is they don't take cases based on for political reasons. They take cases based on the signals that they're getting from the lower courts. But oftentimes we can perceive those as political. And this is why the courts are such an important battleground, because if you aren't taking your problems to the courts and trying to work your cases through there, the Supreme Court isn't going to get the signal. And so it does become political in a way, but it's not the justices being political. It's them responding to what's happening on the ground. And so that's why our case is so important tomorrow on Tuesday, and why if you're out there and you're considering legal action, or maybe you took some legal action in the past and nobody was biting, perhaps now is the time to reconsider that legal action on your religious exemption that was denied. The EEOC has also accepted Hardison as prescribing more than de minimis test, though it has tried to soften its impact, cautioning against extending the phrase to cover such things as the administrative costs involved in reworking schedules, the frequent or temporary payment of premium wages for substitute and voluntary substitutes and swaps when they are not contrary to a bona fide seniority system. So they have set out some certain standards in terms of the cost, but again, it's not substantial enough in the opinion of the court. Yet some courts have rejected even the EEOC's gloss on de minimis, rejecting accommodations the EEOC guidelines consider to be ordinarily required. So the EEOC, it doesn't necessarily matter what they say. A lot of times the courts still side with the employers. The court agrees with the Solicitor General that Hardison does not compel courts to read the more than de minimis standard literally, or in a manner that undermines Hardison's references to substantial cost. So, and again, this is what this decision is really going to focus on in Groff, is what does it actually cost in terms of dollars to the employer? The court holds that showing more than de minimis cost, as that phrase is issued in common parlance, does not suffice to establish undue hardship under Title VII. Right? So again, common parlance. What you or I might interpret a phrase to mean from our understanding is much, much different than what it means legally. You actually have to read the case and understand the context of the case. But the courts haven't been doing that. They've been stripping the context of the case from the words and making the words mean whatever they want them to mean. In describing an employer's undue hardship defense, Hardison referred repeatedly to substantial burdens, and that formulation better explains the decision, right? So because the employer was saying it's going to cost us a lot of money to make this accommodation, that's why it was okay for them not to accommodate. It didn't have anything to do with the minimal standard. The court understands Hardison to mean that undue hardship is shown when a burden is substantial in the overall context of the employer's business, right? So instead of being de minimis, it's substantial. This fact-specific inquiry comports with both Hardison and the meaning of undue hardship in ordinary speech. To determine what an employer must prove to defend a denial of a religious accommodation under Title VII, the court begins with Title VII's text. The statutory term, hardship, refers to, at minimum, something hard to bear, and suggests something more severe than a mere burden. If Title VII said only that an employer need not made to be suffer a hardship, an employer could not escape liability simply by showing that an accommodation would impose some sort of additional cost. Adding the modifier undue means that the requisite burden or adversity must rise to an excessive or unjustifiable level. Right? So everybody's been focused on the de minimis, right, part, but really substantial burden, right? Excessive, unjustifiable. This is really the words that we need to be focused on. Understood in this way, undue hardship means something very different from a burden that is merely more than de minimis, i.e. very small or trifling. The ordinary meaning of undue hardship thus points towards a standard closer to Hardison's references to substantial additional costs or substantial expenditures. Further, the court's reading of the statutory term comports with pre-1972 EEOC decisions. So nothing in that history plausibly suggests that undue hardship in Title VII should be read to mean anything less than its meaning in ordinary use. And no support exists in other factors discussed by the parties for reducing Hardison to its more than de minimis cost line. So this is big here, that we're going to be focusing on the undue hardship, not the de minimis. The parties agree that de minimis test is not right, but they differ in the alternative language they propose. So saying both Groff and DeJoy say, okay, this test isn't right, but if we're going to remake it, we have different ideas about how we might do that. The court thinks, or maybe it's the party, so maybe the party is the court and the petitioners. The court thinks it is enough to say that what an employer must show is that the burden of granting an accommodation would result in substantial increased cost in relation to the conduct of its particular business. So this is what the court is saying, right? Yeah. Hardison, okay. Court must apply the test to take into account all relevant factors in the case at hand, including the particular accommodation at issue and their practical impact in light of the nature, size, and operating cost of an employer. The court declines to adopt the elaborations of the applicable standard that the parties suggest, either to incorporate Americans with Disabilities Act case law or to opine that the EEOC's construction of Hardison has been basically correct. So the court declines to adopt the elaborations of applicable standards that the parties suggest. Right? So I guess the petitioners, they want to expand this out even further, but the court is saying, no, we're going to stick to this standard that has been previously defined, and we're going to make sure that the courts focus on that standard rather than the de minimis standard. A good deal of the EEOC's guidance in this area is sensible and will, in all likelihood, be unaffected by the court's clarifying decisions. Saying, the most part, the EEOC has actually had it correct. It's the courts that have kind of been getting it wrong. But it would not be prudent to ratify in toto a body of EEOC interpretation that has not had the benefit of clarification the court adopts today, right? Because the EEOC, they are an agency. They are supposed to be, monitoring and making sure that the law is being enforced correctly. But they themselves, they don't make law. They don't make case law. All they do is enforce it. And so that's why the courts need to step in to clarify things for them from time to time. What is important is that undue hardship in Title VII means what it says, and courts should resolve whether a hardship would be substantial in the context of an employer's business in the common sense manner that it would use in applying such test. The court also clarifies several recurring issues. First, as the parties agree, Title VII requires an assessment of possible accommodations' effect on the conduct of the employer's business. Impact on the coworkers are relevant only to the extent that those impacts go on to affect the conduct of the business. So this is an important point. I'll read it again. Impacts on coworkers are relevant only to the extent that those impacts go on to affect the conduct of the business. So it doesn't really matter what your coworker thinks of you having that day off. What matters is, can the job get done, and how much does it cost the business to get it done without that person? A court must analyze whether that further logical step is shown, right? So that further logical steps would be if it goes on to affect the conduct of the business. Further, a hardship that is attributable to an employee's animosity to a particular religion, to religion in general, or to the very notion of accommodating religious practice cannot be considered undue, right? So again, if an employee is angry that this person has the day off and that animosity is impacting the conduct of the business, right? If they're like, well, I'm not going to work either, or if they cause a disruption because they're angry that they do have to work, that's not the person whose religious practices, who has their religious observances. That's not their fault. And that's not undue hardship. That's actually the fault of the person who's getting angry and upset, right? Bias or hostility to a religious practice or accommodation cannot supply a defense. So again, it can't just be, I would say, in the case of my situation where I was fired for not complying with the vaccine mandate in New York City, it wouldn't matter that the other people in my job felt uncomfortable because I was there unvaccinated. It wouldn't matter that, oh, well, I'm not going to work with her because she's unvaccinated. That's not undue hardship on the employer. That is actually that other employee being insubordinate then. And that needs disciplinary action. But that's not undue hardship because nobody will work with me. So I think that this is this is probably the most important part of the decision, and I think is also going to come into play because this post workers case, it got sent back down to the lower courts for reconsideration, and we saw that a lot of the issue in the post office was actually other employees kind of being upset that they had to cover for him. Not necessarily that it was going to cost the employer more money, but that these other people were upset. So that, I think, is going to be a very key issue when the courts relitigate it. Second, Title VII requires that an employer reasonably accommodate an employee's practice of religion, not merely that it assesses the reasonableness of a particular possible accommodation or accommodations, right? So it can't just say that they're looking at accommodations. They actually have to do that accommodation. Faced with accommodation requests like Groff's, an employer must do more that conclude than conclude. I think that this is a typo. Must do more than conclude that forcing other employees to work overtime would constitute undue hardship, right? So it can't just say, that's hard for us, we have to make other employees work. They have to actually show it. Consideration of other options would also be necessary. Having clarified the Title VII undue hardship standard, the court leaves the context-specific application that clarified standard in this case to the lower courts in the first instance. So that's just saying that, okay, we clarified what the standard is. We're refocusing the courts from this de minimis standard to the undue burden standard. So like has to show substantial burden in this financial way, and now sending back down to the lower courts. This was a 9-0 decision. That is very, very significant and authoritative. There were, however, concurring opinions. So Justice Alito delivered the opinion of the court, which we're going to go through. What we just read was sort of a summary, a good summary. But there was also a concurring opinion, which I think is actually the one that we're gonna really want to dig in and look at, because it's interesting that the so-called liberal justices are going to be really sticking up for the employer more. So, I think actually the summary does a really good job at getting at what Alito writes. I think that it's important to, let's go ahead and read it. So Justice Alito delivered the opinion of the court. Title VII of the Civil Rights Act of 1964 requires employers to accommodate the religious practice of their employees unless doing so would impose an undue hardship on the conduct of the employer's business. Based on a line in the court's decision in the Trans World Atlantic Inc. v. Hardison, many lower courts, including the Third Circuit Court below, have interpreted undue hardship to mean any effort or cost that is more than de minimis. In this case, however, both parties, the plaintiff petitioner, Gerald Groff, and the defendant respondent, the Postmaster General, represented by the Solicitor General, agree that the de minimis reading of Hardison is a mistake. With the benefit of thorough briefing and oral argument, we today clarify what Title VII requires. Gerald Groff is an evangelical Christian who believes for religious reasons that Sunday should be devoted to worship and rest, not secular labor and the transportation of worldly goods. In 2012, Groff began employment with the USPS, which has more than 600,000 employees. He became a rural carry associate, a job that required him to assist regular carries and the deliver of mail. And so he's in a rural area. When he took the position, it generally did not involve Sunday work, but within a few years that changed. In 2013, USPS entered into an agreement with Amazon and began to facilitate Sunday deliveries. And in 2016, USPS signed a memorandum understanding with the relevant union, the National Rural Letter Carriers Association, that set out how Sunday and holiday parcel delivery would be handled. During a 2-month peak season, each post office would use its own staff to deliver packages. At all other times, Sunday and holiday deliveries would be carried out by employees, including rural carrier associates like Groff, working from a regional hub. So for Quarryville, Pennsylvania, where Groff was originally stationed, the regional hub was a Lancaster annex. The memorandum specifies the order which USPS employees are to be called for Sunday work outside the peak season. First in line are each hub's assistant rural carriers, part-time employees who are assigned to the hub and cover only Sundays and holidays. Second are any volunteers from the geographic area who are assigned on a rotating basis, right? So this is going to be that agreement with the union about the order in which people have to work. So it's like a seniority scheme. Third are all other carriers who are compelled to do the work on a rotating basis. Groff fell into this third category, and after the memorandum of understanding was adopted, he was told that he would be required to work on Sundays. He then sought and received a transfer to Holtwood, a small rural USPS station that only had 7 employees, and at that time did not make Sunday deliveries. But in March 2017, Amazon deliveries began there as well. With Groff unwilling to work Sundays, USPS made other arrangements. During the peak season, Sunday deliveries that would have been otherwise performed by Groff were carried out by the rest of Holtwood staff, including the postmaster, whose job ordinarily does not involve delivering mail. During other months, Groff's Sunday assignments were redistributed to other carriers assigned to the regional hub. Throughout this time, Groff continued to receive progressive discipline for failing to work on Sundays. Finally, in January 2019, he resigned. All right, so that's the background of the case. Gives you a little bit better of an idea of what went on. And again, he did try to make other arrangements to be able to observe his religious holiday. A few months later, Groff sued under Title VII, asserting that USPS could have accommodated his Sunday Sabbath practice without undue hardship on the conduct of business. The district court granted summary judgment to USPS, right? So that means that Groff lost and the United States Postal Service won. The Third Circuit Court affirmed, right? So he appealed the decision, and the Third Circuit Court of Appeals said, nope, United States Postal Service was within their right to deny this accommodation and discipline Groff. The panel majority felt that it was bound by the ruling in Hardison, which it construed to mean that requiring an employer to bear more than a de minimis cost to provide a religious accommodation is an undue hardship. So again, that line that we talked a lot about. Under circuit precedent, the panel observed this was not a difficult threshold to pass. And it held that this low standard was met in this case, right? So it was basically saying that this Hardison standard, yeah, they got over it because it's not a high bar to pass. It's a very low standard. Yet we know that religious liberties in this country are one of the most important and foundational elements. Exempting Groff from Sunday work, the panel found had imposed on, and again, this is interesting because the panel found that it imposed on his co-workers, disrupted the workplace and workflow, and diminished employee morale. So you can see it's very focused on the emotions and the feelings of the other employees and not actually on the cost that it would have taken on the business in terms of financial burden. Judge Hardiman dissented, concluding that adverse effects on USPS employees in Lancaster or Holtwood did not alone suffice to show the needed hardship on the employer's business. So there was a judge in this lower court ruling that said that actually isn't what we should be focused on. It shouldn't matter how the other employees feel. It should be focused on how it impacts the business alone. And the Supreme Court agrees with this dissenting judge. There's lots of cases that were making their way up in these regards throughout the years. You can see the courts had been ruling in this way, so Supreme Court took it up. Because, so I'm not going to go through the rest of this. We really did summarize it on these first few pages up here. And I think that with that background information in the opening, right, the syllabus, we really covered all of the key points in the deciding opinion. We got some pretty good background that I think clarifies some of the circumstances and reaffirms some of those key points in the decisions. But I do want to read the concurring opinion from Sotomayor and Justice Jackson, who's the newest Supreme Court judge, because they wrote their own concurring opinion, which is going to have a slightly different interpretation on what this should mean and clarifying what they think are important points that might have been missed in the opinion of the court. So that, again, we can see it's not always just the opinion of the court that matters. A lot of time it is these dissenting opinions or sometimes these concurring opinions that bring in factors that the opinion of the court might have missed or lower courts ignore. So let's go down here and see if we can find... Keep going. This is the opinion. Well, the good news is that the concurring opinion won't be too long since we're almost there. Okay, so let's read the concurring opinion. This is from Justice Sotomayor and Justice Jackson. These are considered the liberal judges on the court, or the progressive judges, right? It's not supposed to be a political position, but justices certainly have their own biases and their own ways of reading the Constitution, and we know based on which president puts them into their position of power, they're likely going to lean more favorably to the types of policies that that president likes. And Justice Jackson was put in place by Biden. I believe Sotomayor was under Obama. I could be wrong, but as both parties here agree, the phrase "more than a de minimis cost" from TWA versus Hardison was loose language. An employer violates Title VII if it fails to reasonably accommodate an employee's religious observance or practice unless the employer demonstrates that accommodation would result in undue hardship on the conduct of the employer's business. The statutory standard is undue hardship, not trivial cost. Hardison, however, cannot be reduced to its de minimis language. Instead, that case must be understood in the light of its facts and the court's reasoning. The Hardison court concluded that the plaintiff's proposed accommodation would have imposed an undue hardship on the conduct of the employer's business because the accommodation would have required the employer either to deprive other employees of their seniority rights under collective bargaining agreement or to incur substantial additional costs in the form of lost efficacy or higher wages. All right, so again, sort of just repeating what was already said. The EEOC has interpreted Title VII's undue hardship standard in this way for 7 consecutive presidential administrations from Reagan to Biden. Petitioner Gerald Groff asked the court to overrule Hardison and to replace it with a significant difficulty or expense standard. The court does not do so, right? This is a wise choice because stare decisis has enhanced force in statutory cases. Kimball v. Marvel Entertainment, Congress is free to revise the court's statutory interpretations. The court's respect for Congress's decision not to intervene promotes the separation of powers by requiring interested parties to resort to the legislative rather than the judicial process to achieve their policy goals. Right? So again, this is basically saying that you can't legislate from the bench. If Congress comes in with a law or changes a law, that is what has priority, and the court can then only interpret issues based on that law. This justification for statutory stare decisis is especially strong here because Congress has spurned multiple opportunities to reverse Hardison openings as frequent and clear as the court ever sees. So she's basically saying the court made the right decision, right? The plaintiff wanted the language to be changed to, what did they want it to be changed to? Where is it? So the petitioner said that the language in the standard should be changed to significant difficulty or expense. And what they're saying here is this is the language that Congress has chosen, and we can't legislate from the bench. If Congress wants that language, they can change that language. And I agree with that. That's 100% correct. Groff also asked the court to decide that Title VII requires the USPS service to show undue hardship to its business, not to Groff's coworkers, right? So he's saying that, and this is where the court is going to focus, right? Not on what the employee, the coworkers think, not that they're mad that they have to take up extra shifts because this person's religious practices, but actually its impacts on the business. The court, however, recognizes that Title VII requires undue hardship on the conduct of the employer's business. Because the conduct of a business plainly includes the management and performance of the business's employees, undue hardship on the conduct of a business may include undue hardship on the business's employees. And so this is where the concurring opinion from Sotomayor and and Jackson are diverging from the court's opinion. They really are underscoring that actually you can take into consideration how other employees, go about their business now that they have to take up extra shifts, that they have lower morale. These things do impact the business. There is no basis in the text of the statute, let alone in economics or common sense, to conclude otherwise. Indeed, for many businesses, labor is more important to the conduct of business than any other factor. So while the court's opinion is really focused on the financial burden, these justices are saying, well, you can't always put into financial terms the most important factor of the business, which is the labor. And I cannot get over that these are supposed to be the liberal judges, right? The judges for the people, for the workers, and they're siding with the business. They're saying that that the labor force is the most important thing for the business. I don't think that I'm articulating that very clearly, but to me, this is the opposite of what these, liberal people should be arguing, right? They're talking about economics, right? I thought that they're supposed to be the people for the people over money in business. To be sure, some effects on coworkers will not constitute undue hardship under Title VII. For example, animus toward a protected group that is not a cognizable hardship under any anti-discrimination statute. So, they're saying it's one of these things that's difficult to define out. They're saying that, yeah, it does matter how other people feel about taking up more shifts for this person who needs their day off. But if it doesn't come from a place but if it does come from a place of animus against that religion, then that's wrong. Really blurring the line here, these ladies are. Somebody said it's communomics they're talking about, which I think is a reference to communism. It's kind of funny. In addition, some hardships such as labor costs of coordinating voluntary shift swaps are not undue burden because they are too insubstantial. Some hardships such as some hardships such as the labor costs of coordinating voluntary are not because they are too insubstantial. All right, so they're just saying like shift swaps, the expectation of swapping shifts is not undue. Like they should do that. Nevertheless, if there is an undue hardship on the conduct of the employer's business, then hardship is sufficient, even if it consists of hardship on employees. With these observations, I join the opinion of the court. So just an interesting sort of, tack on here from Sotomayor and Justice Jackson, making sure that people with religious viewpoints, making sure that the employer still has some room here when it comes to denying religious accommodations, right? It can't just be financial, as the court's opinion said, that we should actually take into consideration the feelings of other employees. We're going to see how this plays out, right, in the lower court, because Groff's case has been sent back down to that lower court to relitigate based on this clarified standard, emphasizing the financial burden aspect. But again, it does seem like Sotomayor and Jackson have given them a little bit of wiggle room to take into consideration these feelings of other employees who had to pick up extra shifts. That's all interesting, but I have to admit, more interested in the case that I'm part of and how this is going to impact people who were seeking religious accommodations for refusing the COVID-19 vaccination. We have our case coming up on July 18th. That's in Tuesday, so that's 2 days from now. Tomorrow's Sunday, Monday, so the third day. And if you're in New York City, come out and support us, especially if you are a teacher or an educator. Come out and support, especially if you are a teacher or an educator who filed a religious exemption and had it denied. We are trying to get this case certified as class action. And we have to show, just like the Supreme Court really looks down at the lower courts for what signals are being sent and what issues need to be clarified, these judges need to see how many people are impacted so they are more moved to say, yes, this needs to be a class action lawsuit so that we can make sure the hundreds, it was hundreds, if not thousands of people who were either forced into early retirement, forced to quit, were fired. We need to see some justice. So if you're not in New York City, but you're following along, we always appreciate donations. You can go to teachersforchoice.org. You can donate. You can stay up to date on everything medical freedom that has to do with teachers and really just in New York State in general. If you're looking in from another state and trying to figure out, well, how can I get justice for myself? Wherever you might be, take a look, see the things that we're doing, the legal arguments that we're taking, some of the tactics that we're employing, and use them yourself. And of course, reach out. If you are somebody who is looking for some direction, not sure where to start, I'm not a lawyer. I can't promise I have all of the answers, but please, please, please reach out. I will do my very best to, put you in contact with people who can give you better advice, point you in the direction of resources, and just keep up that energy and the morale, because it is a long road to justice. I lost my job as a New York City teacher in October of 2021. It's now a year and a half, a little more than that later, and it hasn't been easy. I know teachers who lost everything. I know teachers who were super deep into their careers, almost, more than halfway to their pension. I was only, that would have been my 6th year starting. So I was still pretty new. I wasn't vested, and I consider myself lucky. I had been saving money and really preparing myself to this point. But many people were blindsided, and, different people are focused on different things. And I didn't think that, I honestly thought that, maybe they were going to do the mandates, but then they would back down like they did in many other places. Like in Boston, that was the case. In Washington, D.C., that was the case. For many other employers, that was the case. They kind of came out strong, but then when you work the system, you could get a religious exemption or get by. So there's people who have really, really, really had a tough past year and a half, 2 years. So if you are one of those people, please reach out and let's see if we can help connect you with some resources, or if anything, just connect you with a network of people who understand what you're going through and can help build you back up to remake yourself. Because I do truly believe that those people who stood up to the mandates and who may have lost their job doing so or had other repercussions, this is the path that you were put on for a reason, that God pulled you out of that classroom or whatever that job was or whatever that path you were on to put you on this path right here. So it's hard. It can be financially devastating. I'm certainly digging myself out of a hole here still, but you have everything you need within yourself and by looking towards God or whatever your higher power is. So stand strong. I appreciate you. I love your beautiful face. Thank you to everybody who's come through Trumbull Schools, hitting that like button. Thank you so much. If you haven't done that, please make sure you do. Yes, John, God first, the rest will follow. That is very true. I do believe that. I try to live that. Sometimes we lose hope Sometimes you do have those moments where your faith falters, and that's why we're here to pick each other back up and stay strong. So again, hit that like button, subscribe if you're new here, share this out with a friend so that they can get up to date. This is important information that, like I said, there's so many headlines that fly past us, and a lot of times we miss the larger framing. We miss the legal underpinnings, and so we really don't understand what's going on. And that's what we're trying to do here. We're really trying to bring in that bigger context. We're really trying to go straight to the source. We're reading the cases for ourselves, not getting caught up in the headlines or in the culture wars. We are teaching liberty, and we're thinking free, we're living free, and I will catch you back here definitely next Saturday night, but I should have a few videos posted up throughout this next week as well. Thank you, everybody. Have a wonderful night, and keep fighting that good fight.